I don't believe you'll be a good candidate for probation. So in each case, I'm going to find you guilty. All right. And are you Mr. Vitale?
Yes, ma'am.
All right. In each cause number, you entered a plea of no contest to aggravated robbery. And each cause number, the plea bargain agreement is to be assessed at a cap of 10 years in the prison. The state opposes your application for deferred adjudication. Have both parties had a chance to review the PSI report? State?
Yes, Your Honor.
Defense?
Yes, Your Honor.
All right. Any objections to the PSI report? State?
No, Your Honor.
Defense?
No, Your Honor.
All right. Any witnesses? State?
No, Your Honor.
Defense?
No, Your Honor. Allocution.
All right. State your post?
Yes, Your Honor. Could I reserve until after the defense, Judge, or?
No, I mean, whatever evidence you want to present to the court as to why you're opposed, and then the defense will go.
I just have argument, but Judge, we're opposed to the application for probation. The facts of the incident, like the cases that the defendant is pleading to today are knife robbery at a McDonald's, which is an inherently scary offenses, Judge. The state did take 2 of those into account, Judge, and we think the 10 years is reflected is a fair sentence for that, Judge. I know you've had an opportunity to look at the TAP evaluation, but the defendant's criminal history is on page 2, and I see a pattern, and it's escalating criminal history, starting with juvenile, moving on to misdemeanor to felonies. He also has assaultive, a couple of ABIs outside of the county, Judge. Also on page 5, the victims were of the TAP evaluation. The victims have told probation that they were scared. Of course, being threatened with maggots is a scary thing. They're seeking medical attention, some sort of counseling to help them deal with that. Also on page 7 of the TAP evaluation, I don't think I can say it any better than the victim said it. He's obviously not a good candidate for probation, Judge. Also on page 11 of the TAP, towards the bottom there, he's really, the defendant is minimizing his culpability. He's not recognizing these are choices that he made. Says, I was on the Xanax and methamphetamines that day, so I honestly don't remember what I was doing. This is not somebody who's taking responsibility for their actions, Judge. This is someone trying to minimize their culpability. When asked why he felt he should be granted probation, the defendant said, because I really don't want to go to prison. I'm not meant for that. Judge, this is not somebody who's taking responsibility for their actions. We're asking for the 10 years, Your Honor. All
right, defense.
Your Honor, the PSI reflects the root of these problems are threefold. He's got a mental illness, got a 7th grade education, he takes drugs. You can fix all those problems with an intensive supervised deferred adjudication and a McMild supervision. I ask that you award 10 years deferred adjudication. Moment, please, Your Honor. Nothing further, Your Honor.
All right. Did you wish to say anything or no?
No, Your Honor.
Okay. All right. The court has reviewed the PSI report. I always reread the stipulations, which in this case, Mr. Vitale is the police reports and everything that was submitted to the court. And it does appear from the PSI report that you're continuing with criminal behavior. As I look at your PSI report, you had juvenile cases. And then you have cases as an adult, the discharging of a firearm, unlawfully carrying a weapon. And in those cases, you had a motion to revoke filed against you. And then we have another unlawfully carrying of a weapon in April of 2020, evading arrest or detention in September 2021. And then your felony cases, the unauthorized use of a vehicle And then we have the aggravated robberies. And I understand when people have mental health issues. I understand when they have drug issues, but that's not an excuse. That's more medication. You understand? All right. I don't believe you'll be a good candidate for probation. So in each case, I'm going to find you guilty. Would anyone like to speak with regards to the cap? State you're asking for the 10 years?
Yes, Judge, I feel like the 10 years is an appropriate sentence. Based on the severity of this crime. This was a robbery with a knife, Judge. It's pretty scary. I think as the judges pointed out, as you pointed out, Judge, it's escalating behavior. So it starts as misdemeanors and then it goes up to these more and more dangerous activities, Judge.
I suggest to the court 6 years, Your Honor. He's no evidence that he's misbehaved in jail. That he hurt any police officers when he was arrested. And cooperative with this court. And with probation.
All right. Does anyone want to speak with regards to restitution?
Whatever the court orders, Your Honor.
Judge, the TAP evaluation indicates that there's restitution to Jathan Cantu on page 5. It's JATHYNCANTU of $120.
Defense, do you have any objection to that?
No objection.
On page 6, it's restitution to Alan Hernandez of $1,078.
Any objection?
No objection.
There's no restitution on page 7. There's no restitution amount for the other victim. The third victim is Ali Sefraoui, ALI, and then the last name is SEFRAOUI. So I just asked that the court order restitution to be determined, Judge.
All right. With regards to the restitution to be determined, the court is not going to allow that. This case has been on the docket since May, awaiting for restitution. And I find that when you say restitution to be determined, what ends up happening is somebody could say they want $30,000. And then Mr. Vitale, though he's done wrong, he won't have an attorney to address the issue of the $30,000. And somebody will just put that, and it'll take a while to clear that up.
Yes, ma'am.
All right.
Well, there's one final complaining witness, Judge. Sorry, on page 8, Damian Ortiz, he said that his monetary loss was $250, Judge.
Any objection?
No, Your Honor.
Mr. Vitale, your attorney is telling me that you have mental health issues and that you have drug issues. If you would like, the court could recommend the therapeutic community for you. It doesn't increase the time that you spend at the prison, but they can help you if you so choose. So would you like to be considered for the therapeutic community? All right, you'll still have to ask for it though. All right, and cause number 2023 CR 3033, the court will find you guilty, sentence you to 10 years in the prison. There's an affirmative finding of deadly weapon. This will run concurrent with 2023 CR 3036. Take in consideration 2023 CR 3034, 2023 CR 3035. There's to be restitution of $120 to Jathan Cantu, restitution of $1,078 to Alan Hernandez, restitution of $250 to Damian Ortiz. And cause number 2023 CR 3036, the court will find you guilty, sentence you to 10 years in the prison, give you credit for any time served. There's an affirmative finding of deadly weapon. This will run concurrent with 2023 CR 3033. Take in consideration 2023 CR 3034. 2023 CR 3035. There's to be restitution to the following: $120 to Jathan Cantu, $1,078 to Alan Hernandez, $250 to Damian Ortiz. And in each cause number, the court will recommend the therapeutic community. Is there anything else from either side with regards to sentencing in either cause number?
No, Your Honor. No, Your Honor.
All right, showing you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it? And did you sign it in both places? All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand? Because this is a felony conviction in each cause number, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you need to speak to an attorney. Do you understand? All right, we can go off the record. Are there going to be victim impact or no?
No, Judge.
All right, so here's the thing. How old are you? 28. 10 years is a long time. I personally think any time that you're confined is a long time. I remember when I was a defense attorney, people would make an offer to my client and they'll say, oh, they can do 2 years standing on their head. And you know what I would always tell the person? Have you ever done time? Until you've done time, you can't say that. So I realized that every single day locked behind bars is a long time. But you're going to have to do better. I see that you have children. If you don't do better, you know what's going to end up happening? You're going to end up spending the rest of your life at the prison. You understand? So I'm giving you a chance to take advantage through the therapeutic community, and you got to do better. Otherwise, you're going to be the grandpa at the prison. Don't be that person, okay? All right, good luck to you. Could I get the dismissals?
Yes, ma'am.
Yes. No, he has 2 dismissals.
Oh.
And that's in 3034 and 3035. It's always good seeing you, Mr. Callahan.
Your Honor, good to see you. Be seen.
Yes. That's what people always say. It's good to be seen. And Caroline, they're going to submit the dismissals.
You have to excuse your Honor.
Yes. Do you want to wait for your dismissals? All right. The court is calling 2023 CR 2080A, State of Texas versus Shawana Canales. Can I have parties announced for the record for the state? For the state, sorry. Nope.
Jason Garahan.
For the defense?
Robert Barrett on behalf of Kelly.
All right. And are you Shawana Canales?
Yes.
Do you have any objections to Mr. Barron standing in for Ms. Green?
No.
All right, state any objections?
No.
Counsel, have you received all the discovery and did you review it with your client?
Yep.
Court will find that the state is in compliance with discovery. Ms. Canales, I'm showing you what's entitled application for deferred adjudication, community supervision. Did you review that with your attorney? Did you understand it? Did
Yes.
you sign it?
Yes.
Showing you what's entitled true bill of indictment. Did you review that with your attorney? Did you understand it?
Yes.
Counsel, do you waive the reading of the indictment? State, are you proceeding on the indictment as presented?
Yes, we are.
Showing you what's entitled court admonishments. Did you review that with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
Did you understand you're charged with the offense of theft, 2,500 to 30,000? That's a state jail felony. The range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. Did you understand?
Yes, ma'am.
If you have a plea bargain agreement with the state, the court does not have to follow your plea bargain agreement. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, ma'am.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes.
And did you intend to give up those rights and enter into a plea in this case?
Yes.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty, sentence you up to 2 years in the state jail facility and up to a $10,000 fine?
Yes.
Counsel, has your client been able to provide you with any defenses?
Been able to assist in her defense. I believe she understands.
All right, do you believe she was sane at the time of the offense?
I do.
Ms. Canales, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea? Has anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes,
Are you a U.S. citizen?
yes,
Court will find that defendant has knowingly and voluntarily waived her right to jury trial, showing you the plea bargain page. Did you review that with your attorney? Did you understand it?
yes, ma'am.
According to the plea, there's a $500 fine. State recommends deferred adjudication. They will take in consideration night bag number 711174. Did you understand that to be the plea?
Yes, ma'am.
Defense?
Yes.
State?
It is, Your Honor.
Showing you the waiver of appeal paragraph. Did you review that with your attorney? Did you understand it? Did you sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes,
Counsel, are there any such motions?
No, Judge.
Next, I'm showing you outside the agreement. The state is recommending that your deferred adjudication be for a term of 2 years. There be a TAP evaluation, 140 hours of community service restitution, and no contact with Clifton Smith. Did you understand that those are recommendations from the state
yes,
and the
ma'am.
court does not have to follow those?
Yes, ma'am.
Then to the offenses charge, how do you plead? Guilty, not guilty, or no contest?
No, ma'am.
State any evidence
State executive number one with all its attachments, Your Honor. There's no objection, Your Honor.
showing you the waiver and consent to stipulation of testimony and stipulations. Did you review that with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call it the right to remain silent?
Yes, ma'am.
Did you understand that today the state would be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence States Exhibits 1 and attachments and review the same. All right, after reviewing States Exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty. Court defer finding of guilt as you've applied for deferred adjudication. Are you proceeding with sentencing? Anything you wish to say on behalf of your client?
Best that the court follow the plea bargain.
All right, Ms. Canales, what is your relationship to Alejo Aguirre?
None, ma'am.
So why were you with him?
I know him from down the street where I was living at, and he had asked me if he could place a set of tires at the residence. So, I agreed. I went with him to go pick up. And what ended up him picking up tires, ended up him picking up a stack of some pellets, like, those wood pellets.
Mhm.
And that was the reason of the arrest, because he didn't have permission to pick those pellets up.
All right, are you employed?
I don't know, I'm not in,
When's the last time you were employed before being taken into custody?
in 2011.
All right, why have you not worked since 2011?
Mental issues,
All right, what are your mental issues?
schizophrenic and bipolar.
And have you received a professional diagnosis of that?
Yes, I was on medication before in the past. I just stopped taking my medication for a while.
Are you on medication at the jail
Yes.
for the schizophrenia and bipolar?
Stabilized.
Do you have any children? What are their ages?
24, at 23. And then I have a 15-year-old.
All right, where's the 15-year-old?
My 15-year-old's outside the,
Okay. And I'm assuming school's not in session.
and then, I'm
They're
sorry.
enjoying summer.
And then my son is at the,
Backdoor objection.
Okay. So if you're released, do you have a place to stay?
yes, ma'am.
And who would you be staying with?
A friend of mine,
Who is this friend?
Ezekiel Angel.
How long have you known this
I've
person?
known him for all my life, like, since my daughter was born. He's her uncle.
Okay. All right, this is what the court is. I'm sorry, is there any questions from anyone else?
Objection.
All right, this is what the court is going to do. Court is going to sentence you to 2 years deferred adjudication, 140 hours of community service restitution, I'm going to ask for parenting classes. Once she completes the parenting classes, the community service hours will be deemed to be satisfied.
I don't have custody of the children. But I mean, I'll still do that.
Well, I mean, your 15-year-old is here for some reason,
Oh, I'm sorry.
right?
No, yes, I'm sorry. No, I'll do the class.
Okay.
I'm
Nope.
sorry.
Oh, no, there's no problem. I'd like for people to speak so I can figure out what's going on. There's to be no contact with Clifton Smith or Alejo, Alejo Aguirre. Taking consideration NIMAG number 711174. I'm going to want a referral to Center for Healthcare Services, regular reporting by Zoom or in person, regular UAs, and I'm going to want field visits 1 time per month until further notice. And probation, once she is with Center for Healthcare Services and they've given her a case manager, then the court will consider lifting the field visits 1 time per month. All right, probation, is there anything else she needs?
No, Your Honor.
Is there anything else you need from the court?
The TAP evaluation, am I able to take the TAP evaluation out on the free roll or?
Yeah.
Okay.
So why do you think you need the TAP evaluation?
Well, it was in.
Recommended by the state.
Okay, all right, and I'm sorry, we're gonna do proof of employment with proof of employment or SSI within 45 days. And there's to be no employment as a home health care provider or with minors. And I'll allow her to do the TAP evaluation out of custody. You need to make sure you make your TAP evaluation appointment. If you don't make that appointment, then what's going to end up happening is I'm going to receive notice that you haven't made that appointment and a motion to revoke is going to be filed. Do you understand?
Yes, sir. Yes, sir.
All right. And we'll follow whatever the TAP recommendations are. If TAP recommends inpatient treatment, we'll start with intensive outpatient treatment. Is there anything else you need from the court to be successful? All right, I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it? And did you sign it in both places?
Yes, sir.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, sir.
All right, good luck to you.
Thank you. Thank you.
You're welcome. Court is calling 2023 CR 5724W and 2023 CR 5797W, State of Texas versus Sean Kevin McCaslett. Can I have parties announced for the record for the state?
Hank Wilkins for the state, Your Honor.
Will Brooks with the defendant, Sean McCaslett.
And are you Mr. McCaslett? Counsel, have you received all the discovery in each of these cause numbers, and did you review it with your client?
Yes, Your Honor.
In each of the cause numbers, the court will find that the state is in compliance with discovery. And each of the cause numbers, I'm showing you what's entitled Application for Community Supervision. Did you review that with your attorney? Did you understand it? And did you sign it? In each of the cause numbers, I'm showing you what's entitled Waiver of Indictment, Reading of Information and Rights under Article 1.051 and 26.03 of the Code of Criminal Procedure. Did you review that, those documents with your attorney? Did you understand it? And did you sign them? Did you understand by signing that you're waiving your right to have a grand jury hear the evidence in this case? You're also waiving the right of your attorney, certain rights that your attorney has, namely your attorney has 2 days from the presentation of the information and 10 days from the presentation of the information to prepare for trial. Did you understand by entering these plea bargain agreements in each of these cause numbers, you were giving up those rights? And did you intend to give up those rights and enter into a plea in this case? In each of the cause numbers, the court will find that defendant has knowingly and voluntarily waived indictment, reading of information and rights under Article 1.051 and 26.03 of the Code of Criminal Procedure. And each cause number, I'm showing you what's entitled Information. Did you review those with your attorney? Did you understand them?
Yes, sir.
Counsel, do you waive the reading of the information in each cause number?
We do, Judge.
State, are you proceeding on the information as presented?
Yes, Your Honor.
All right, in each cause number, I'm showing you what's entitled Court Admonishments and Defendants Waivers and Affidavit of Admonitions. Did you review those documents with your attorney? Did you understand it? Did you sign it in all the appropriate places? Did you understand in each cause number, you're charged with the offense of theft of aluminum, bronze, copper, less than $20,000 as a habitual offender? So the range of punishment is anywhere from 2 to 20 years in prison and up to a $10,000 fine. Did you understand? If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand? Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent? Did you understand by entering these pleas, you were giving up those rights? Did you intend to give up those rights and enter into a plea in each of these cause numbers? Counsel, in each of the cause numbers, has your client been able to provide you with any defenses?
Yes, he has, Judge.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
That's my belief, Judge.
Mr. McCaslett, has anyone threatened you, coerced you, or placed you in fear to get you to enter the pleas? Has anyone promised you anything other than the pleas? Are you satisfied with the way you've been represented? Are you a U.S. citizen? In each of the cause numbers, the court will find that defendant has knowingly and voluntarily waived his right to jury trial. In each of the cause numbers, I'm showing you the plea bargain page. Did you review that with your attorney? Did you understand it? In each of the cause numbers, according to the plea, punishment is to be assessed at 10 years in the prison. There's a $1,000 fine. State recommends community supervision. The cases will run concurrently. The state will take in consideration 2022 CR 7824. NIMAC number 795249, 795252, and there's to be the anti-theft course plus restitution, if any. Did you understand that to be the plea?
Yes, sir.
Defense?
Yes, Judge.
State.
Yes, Your Honor.
In each of the cause numbers, I'm showing you the waiver of repeal paragraph. Did you review that paragraph with your attorney? Did you understand it? Did you sign it in both places? Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand? Counsel, have there been any such motions?
Motion's been overruled. I'm sorry, motion's been overruled.
Okay. Outside the agreement in each case, the state is requesting that your community supervision be for a term of 10 years. There be a TAP evaluation, random UAs, and sober support meetings to be determined by probation. Did you understand those are recommendations from the state and the court does not have to follow those recommendations?
Yes, Your Honor.
Then in each cause number, how do you plead? Guilty, not guilty, or no contest? State in each cause number, do you have any evidence to support the defendant's plea?
Yes, Your Honor. I submit State's Exhibit 1 in the attachments, Judge.
We've reviewed both in both cases, Judge, and we have no objections.
In each of the cause numbers, I'm showing you what's entitled waiver and consent to stipulation of testimony and stipulations. Did you review those documents with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call them the right to remain silent?
Yes, Your Honor.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there'll be no live testimony. Did you understand? In each of the cause numbers, the court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence State's Exhibits 1 and attachments. All right, Mr. Haslett. And each cause number to the enhancements, how do you plead, true or not true? In each of the cause numbers, after reviewing State's Exhibits 1 and attachments, the court will find you guilty and the court will find the enhancements true based upon your plea of true and also based upon State's Exhibits 1 and attachments. Are you proceeding with sentencing?
Judge, we'll waive a PSI.
All right, anything you wish to say on behalf of your client?
Your Honor, in respect to Mr. McCaslett, you struggle with drugs. I've got a pretty extensive background on him from my investigator. Fortunately, he came up in a very tough home. His mother was an addict. Mental health issues, I'm sorry. That was today, 3 years ago.
Okay, we can't hear.
She passed 3 years today. It's around her recently.
Okay,
And he struggled with addiction, Judge. These are the result of the same, but in this instance, Judge, he's been in custody for 4 months. He's made a decision that he wants to change.
all right. Do you have any children, Mr. Haslett?
Yes, ma'am, I do.
And what are their ages?
A 17-year-old man, 13 and 3 girls.
And do they stay with you or no?
And then
So who do they stay with?
her mother.
Has Child Protective Services ever been in your life? And when's the last time you had employment before being arrested?
I want to say in January. That's good for them.
And have you had any type of treatment before?
Yes, ma'am, Your Honor, I also have a sponsor out there.
A sponsor?
Yes, ma'am.
Have you ever had any inpatient treatment? What type of inpatient treatment?
Static.
All right. All right, and each cause number, this is what the court will do. Court will sentence you to 10 years in prison, suspended and probated for 10 years. There's $1,000 fine. That will be probated. This will run concurrent. Each case will run concurrently. Take in consideration night mag number 795-249, 795-252, 2022 CR 7824. Counsel, since you're in felony drug court, is his history such that felony drug court, he would pass the screening?
It may be, Judge.
Okay,
I don't know what the status is as far as numbers go. But we talked about it before. I think she's willing to get some help, certainly, Judge.
all right, we're gonna do a felony drug court and TAP evaluation in custody. Proof of employment within 45 days of release. There's to be no employment as a home healthcare provider or with minors. CATs 1 and 2. Regular reporting by Zoom or in person. The UA hotline. Field visits. 1 time per month. Until further notice. 100 hours of community service restitution. And once you complete parenting classes, those will be deemed to be satisfied. Is there anything else with regards to sentencing from either side?
I think the state's got to
Dismiss.
dismiss and then also the TIC, Judge.
Mhm.
Yes, and misdemeanors, and I'll make sure we get those set up.
All right, probation, is there anything else he needs? And each of the cause, is there anything else you need from the court? All right, and each of the cause numbers, I'm showing you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that document with your attorney? Did you understand it and did you sign it?
Yes, Your Honor.
Because this is a plea bargain agreement, because I followed your plea bargain agreement and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand? Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. You understand? All right, Mr. Haslett, good luck to you. We can go off the record. And this court, communication is key. So if there is an issue, let probation know. If you feel as though probation is not addressing it, then just let the court know. Okay?
Thank you.
All right, good luck to you. You're gonna have to do better, okay?
Yes, ma'am.
Court is calling 2023 CR 4007A, State of Texas versus Mario Aguilar. Can I have parties announced for the record for the state
Hank Wilkins for the state, Your Honor.
defense?
Robert Gear, Your Honor, for defendant Mario Aguilar, and we're ready.
All right, and are you Mario Aguilar?
Yes, Your Honor.
Counsel, you received all the discovery. Did you review that with your client?
I have, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Aguilar, showing you what's entitled application for community supervision. Did you review that with your attorney? Did you understand it? Did you sign it?
Yes, Your Honor.
Showing you the true bill of indictment. Did you review that with your attorney? Did you understand it?
Yes, Your Honor.
Counsel, do you waive the reading of the indictment?
We do, Your Honor.
State, are you proceeding on the indictment as presented?
Yes, Your Honor.
Showing you what's entitled court admonishments and defendants waivers and affidavit of admonitions. Did you review that with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, Your Honor.
Did you understand you're charged with the offense of robbery? That's a second-degree felony. The range of punishment is anywhere from 2 to 20 years in prison and up to a $10,000 fine. Did you understand? If you have a plea bargain agreement with the state, the court does not have to follow your plea bargain agreement. If for any reason the court doesn't follow your plea bargain agreement and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, Your Honor.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, Your Honor.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes, Your Honor.
And did you intend to give up those rights and enter into a plea in this case?
Yes, Your Honor.
Counsel, has your client been able to provide you with any defenses?
He has, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do, Your Honor.
Do you believe he's currently competent, was legally sane at the time of the offense? Mr. Aguilar, has anyone threatened you, forced you, or placed you in fear to get you to enter this plea?
No, Your Honor.
Has anyone promised you anything other than the plea?
Your Honor.
Are you satisfied with the way you've been represented?
Yes, Your Honor.
Are you a U.S. citizen?
President.
Counsel, have you had an immigration attorney speak to him?
I have not had an immigration attorney speak with him, Judge, but prior to this situation, he was already being addressed with immigration. Prior to this, he has a court date in immigration court. And from what we know, this is not going to affect what is going on in that.
All right, let's do this. Because I would feel more comfortable if he had a chance to speak to an immigration attorney concerning these charges. So, Ms. Ferguson, can you see if you can have somebody from MAC come down with regards to immigration? We'll take care of this, Mr. Aguilar, but I want to make sure that you know all of your rights. So sometimes things that you do on the criminal side, well, not sometimes, always has an effect or impact on your immigration status, all right? So, Ms. Ferguson, let's see if we can call Mac down, and then once they speak with him, we'll see how long they need for me to make a decision on this, okay?
Yes.
All right, thank you. All right, and the court has signed the protective order. So, Mr. Cox, you're on this side. So we have the CPS records, is that correct?
Yes, Your Honor, I just uploaded them. I offered if Cornelius has a hard drive, I'll put them on that, but they are on e-discovery. It's over 6,000 pages, plus probably about 20 audio interviews.
Mr. Cox, it seems like you're becoming a speed reader. All right, so is that the only discovery that's outstanding? That was the CPS record?
My knowledge.
All right, so Ms. Ferguson, on this case, recall this for 30 days and state at that time, you need to tender an offer.
Okay.
All right,
30 days?
yes, 30 days. And it's for the state to make an offer. August 15th. All right. Denise, I think the only way I could get you in to talk about the LSU Florida game is by having you in court. And you know what? When LSU lost, I think it was like 24-4, you were calling me like on a daily. And then, you know what? That's sort of like that commercial, the thrill of victory, the agony of defeat, but at least you had a victory. Yes. Okay. Clifton Barnes. Hi, what am I being congratulated for?
Not you specifically, but your alma mater.
Oh, yay.
College World Series. Huh?
Yes. And you know, after the 24-4 loss, I can't imagine. The only good thing about having a loss that big is there's sort of nothing to say. The only thing you can say is, you know what, we're going to move past this. We got another game to prepare for.
What else can you do?
Yeah.
Yeah, 24 to, what was it?
I think it was 24-4,
4.
that,
In
that
football,
second game.
That's
Yeah, it's like,
okay, but in baseball, that's a royal something.
well, in football, you're trying to figure out, okay, where did they get that 1 point for? Or did they do
Right,
a lot of touchbacks? What's going on?
right. Well, actually, it could be, if it was 24, then it could be 3 touchdowns
Mhm.
and a field goal.
Well, no, I'm talking about the 4. You know, the 4 points. In
Oh,
football,
the other
yes.
4, yeah,
Yes.
yeah.
Like, where does that come from?
Yeah, that would be. Yeah, where would you get that? in football?
Well,
I mean, a touch, a.
you can do a
safety
touchback.
and 2
Yes, you can do 2 safeties.
or 2 safeties. I
Yes.
guess. That would be about it.
Mhm. So we shall see. We shall see.
So anyway, we've got next month.
Okay.
Starting it up, SEC.
Yeah, we'll see how it goes.
And Texas will be in there next year.
Yes,
So that'll be interesting.
yes. All right, who's here on Anthony Cantu? Anthony Cantu. Who's the attorney for Anthony Cantu?
Oh, it's Mr. Fowler.
All right, just have a seat.